Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 61. In this, the last podcast before Christmas, we're looking at three different cases. The first case looks at restrictive covenants and the need for due payment or other benefit to be given in order for the covenants to be enforceable. The second looks at whether it's possible to carry over holiday leave due to a reason other than sickness. And the final case, it considers a breach of contract on the part of the employer for acting unfairly during the early stages of a disciplinary hearing, and looks at whether the employer can then be liable for the employee's resulting stress-related illness. The only other point I wanted to mention right at the start of the podcast was I had an email in from a listener to the podcast asking if I could repeat the case names at the end of each case section to be sure that they can be picked up. I'm more than happy to do this, of course. The other thing is that I've taken to posting links to all of the cases on my Twitter account. For those of you who use Twitter, can I suggest it might be worth following me? And that's to be Nicholas Robber 11. That's NicholasRober, then the number 1 and the number 1. So Nicholas Robber 11. And then with the same day that the podcast goes live, I put out a tweet with links to the case names and the podcast itself. The first case then is Yap and the Foreign and Commonwealth Office. This is a Court of Appeal decision regarding a failure on the part of the employer to act fairly when allegations of misconduct have been raised against an employee. It considers whether damages for a stress-related illness could be awarded as a result of the employer's breach of its obligations at an early stage in the process. The background to the case is that in January 2007, Mr. Yap was appointed British High Commissioner in Belize. He took up the post in August, and his contract provided that the FCO had a broad discretion, where necessary for operational reasons, to withdraw any head of mission from his or her post. At the start of June 2008, allegations of misconduct were raised, including allegations of sexual harassment. In mid-June, Mr. Yap was invited to a meeting, but was not given any information ahead of time as to the content of the meeting. At the meeting, the allegations were put to him in general terms, and he was told that because of the allegations, his position was untenable, and he had to be withdrawn with immediate effect. So the decision had been taken to suspend him before he had been spoken to. Mr. Yap was told the withdrawal was not a disciplinary step, and that if the allegations were unsubstantiated, then he'd be found another role. After the removal from the post, the FCO subsequently followed its disciplinary procedures and investigations were carried out, and that resulted in a final written warning. But that was purely in relation to his alleged bullying behaviour, and the allegations of sexual harassment were not established. Mr. Yap appealed, but his appeal was dismissed. After the disciplinary hearing was known, the suspension was lifted, but Mr. Yap developed a depressive illness, was not well enough to return to work, and remained on sick leave until his retirement in 2011. Mr. Yap issued proceedings against the FCO in the High Court on the grounds that 1. The withdrawal from the post was a breach of contract and a breach of the employer's duty to take reasonable care for his health and safety, and 2. The way the disciplinary process was conducted amounted to a breach of contract. So what did the High Court decide? Well, the High Court decided that the withdrawal of Mr. Yap from his post was both a breach of contract and a breach of the duty of care which the FCO owed him, but the court dismissed the claims relating to the conduct of the disciplinary process. The High Court decided the FCO had a contractual power to withdraw Mr. Yap for operational reasons, but that power had to be exercised fairly. It held that fair treatment required a preliminary investigation into the allegations before taking the decision to withdraw, and for details of the allegations to be explained to Mr. Yap before a final decision was taken to withdraw him. Therefore, there was a breach of contract and a breach of the duty of care due to his unreasonable withdrawal. Secondly, the High Court considered that the dual role played by one individual in the process, who had both collected the evidence and conducted the disciplinary procedure, was wrong. The judge found that the individual, a Mr. Gifford, had acted fairly and conscientiously. However, it said that it was a, quote, breach of the basic principles of natural justice, unquote, for Mr. Gifford to conduct both the fact-finding investigation and the disciplinary hearing, although ultimately this dual role did not have the result of causing any loss or damage to Mr. Yap. Finally, the High Court considered whether the loss for stress-related illness was too remote. The FCO argued that Mr. Yap had shown himself to be robust, had taken criticisms well, and it wasn't reasonably foreseeable that any unfair withdrawal would lead to him developing a depressive illness. However, the High Court had rejected that argument and said it was reasonably foreseeable, that a knee-jerk reaction to suspend by an employer would lead to serious adverse consequences for an employee, which might include psychological damage. Therefore, the court held he was entitled to recover damages for the depressive illness which he had delivered. FCO appeals against the finding to the Court of Appeal, and they appealed on the basis that the withdrawal was not in breach of its obligations, and claimed that he was not entitled to recover damages for depression because the loss was too remote. In relation to the unfair withdrawal, the court dismissed the appeal by the FCO, confirmed that the FCO had broken its duties owed to Mr. Yap. Even though the FCO enjoyed a broad discretion in relation to withdrawing a post order, the discretion had to be exercised fairly. Withdrawing him immediately, without any chance for him to rebut the allegations, was outside the range of reasonable responses, and it was irrelevant that the FCO went on to treat Mr. Yap fairly in the subsequent disciplinary proceedings. Moreover, it was no argument to say that, because the allegations were given to the FCO on a confidential basis, Mr. Yap could not be informed of any details of the allegations before a decision was taken to suspend. The FCO should have found a way of dealing with the issue of confidentiality, either by disclosing the content of the allegations without revealing the source, or asking the person who raised the allegation for their consent to the disclosure. Furthermore, the court said that the FCO should have found a way of evaluating, at least initially, the allegations against Mr. Yap. There would have been material within the knowledge of the FCO and within its files that could have caused them to be sceptical about some of the allegations that were being raised. There was no evidence they took this initial or preliminary step. Secondly, the Court of Appeal said they disagreed with the finding that it was unfair for Mr. Gifford to act as fact-finder and decision-taker. Court of Appeal referred to the recommendation by the ACAS Code of Practice that, in misconduct cases, there should be different people carrying out the investigation and the disciplinary hearing. However, it couldn't be said to be a principle of natural justice in the way the High Court had said. And the Court noticed that the process recommended by ACAS was, and they accepted it, was good practice. However, in this case, Mr. Gifford's knowledge and of the individuals and the details, having interviewed the witnesses, was an advantage, and justified him taking the role of decision-maker as well as investigator. Now, pausing there, I think the Court of Appeal's comments are really helpful, and I, for one, have long struggled with what to do, where credibility of witnesses is an important factor in evaluating the allegations at the disciplinary stage. I can certainly see that normally it makes sense to separate an investigator and a decision-maker, simply to bring a fresh pair of eyes to look at a particular situation. However, sometimes a lot may depend on the credibility of the complainant, or on the credibility of a witness, or something of that nature. It seems very cumbersome to require the decision-maker to go and re-interview those witnesses, and presumably generating witness statements on notes of meetings, etc., which then have to be disclosed to the complainant and commented on, etc., etc. On the other hand, it doesn't seem appropriate for the decision-maker to rely on the investigator's assessment of credibility. It's clear it will be the exception rather than the norm for the investigator or decision-maker to be one and the same person in a large organisation, but this case does indicate that there may be circumstances where it's appropriate. Finally, the Court of Appeal then moved on to look at the various tests for remoteness in relation to psychiatric illness, and they confirmed the general approach was that psychiatric injury would not usually be foreseeable unless there were indications the employer was, or should have been aware, of the fact that there was some problem or vulnerability on the part of the employee. Whilst it's possible that conduct in one particular case might be so devastating it's foreseeable that a person of ordinary robustness might develop an illness, the High Court was wrong, the Court of Appeal decided, to decide here that it was reasonably foreseeable that the FCO's conduct in withdrawing Mr. Yap from his post could lead to a psychiatric illness. Therefore, the finding that damages should be awarded for the development of that depressive illness was not upheld. Court was asked to distinguish during the argument between cases of continuous pressure caused by overwork and one-off wrongful acts by the employer. The claimant said it might be reasonable to expect a prospective claimant to show the employer knew about the vulnerability of the employee, where it was that what had led to the breakdown was continuous pressure caused by overwork, but said that a different approach should be taken where it was a one-off wrongful act by the employer. But the court disagreed. Criticism or disciplinary action or grievance procedures are a normal characteristic of the employment relationship, they said. It's not uncommon for processes to be flawed to some extent, with a spectrum ranging from minor procedural flaws to gross unfairness. And the court therefore took the view that it is not usually foreseeable that even disciplinary action which is, quote, quite seriously unfair, unquote, will lead an employee to develop a psychiatric illness unless there are signs of pre-existing vulnerability. This case is consistent with the general thrust of other personal injury cases, and it's helpful that the court is continuing to take the view that an employer should not be asked to assume that an employee facing, and this is a quote from the judgment, quite seriously unfair disciplinary action will be likely to develop psychiatric illness. Of course, the employer should seek to do nothing that might be viewed as quite seriously unfair, but often there are two sides in any given situation. On a wider perspective, I think it does really emphasise the need for employers to consider carefully any suggestion of a knee-jerk suspension pending investigation. Even though it was emphasised to Mr. Yap the suspension here did not imply guilt in any way, it did have an effect on him, and the court found he should not have been suspended in these circumstances. In most cases, even where there is a need to act urgently, it's going to be possible to have a conversation with the employee, and during the meeting in question, give them an opportunity, however limited, to respond to the allegations. The employer can then decide, if necessary during the meeting or in a short adjournment after it, that the employee has a case to answer, and so should be suspended. But the employee will have had some opportunity to respond to the allegations. Similarly, before raising matters with the employee who it is alleged has done something wrong, an employer will often be able to carry out some sort of test of the allegations and the possible motivations of the person making the complaint. We do see cases where employers have reached for suspension of an alleged wrongdoing as the initial and automatic first step, but I think there's one lesson to take out of this case, is that that is potentially quite dangerous. Obviously, in many cases, individuals will not develop psychiatric illness as a result. However, it could lead to a claim for constructive dismissal, particularly if an employee is looking for a way out of what might otherwise be a difficult situation. Constructive dismissal could lead to the employer losing its restrictive covenant protection, which may be particularly relevant if the alleged misconduct is in connection with a potential move to a new employer. So, there we have it. That's the case of Yap and Foreign and Commonwealth Office. Now, the next case I want to talk about is the Sash Window Workshop Limited and Mr. Dollar and Mr. King. This is an EAT decision in relation to a claim for unused holiday leave and the quantum of damages for injury to feelings following a finding of age discrimination. Two separate issues. The factual situation was that Mr. King was a commission-only salesman for Sash Window Workshop, worked for them from 1999 to October 2012, when he got to 65, and his employment contract was terminated. At the Employment Tribunal, Mr. King successfully claimed dismissal on the grounds of unlawful age discrimination, and he also brought claims successfully in relation to holiday leave. I'm going to deal with the two elements of the claim completely separately, because they don't really interrelate. The Employment Tribunal was asked to consider three separate elements of holiday pay, and these were christened Holiday Pay 1, Holiday Pay 2, and, stunningly, Holiday Pay 3. Holiday Pay 1 and 2 were awarded to the individual and were not challenged at the EAT stage. Holiday Pay 1, well, that related to accrued but untaken holiday in his leave year in the last year of engagement, so up to October 2012. He was claiming he'd been underpaid because he'd not received holiday pay covering commission payments, and this was accepted by the tribunal and not appealed. Holiday Pay 2 related to pay for leave which he had taken in previous years where he'd actually taken holiday. Again, it was alleged there was a series of underpayments to him, and this was claimed as a series of unlawful deductions from wages, and this too was not appealed. Holiday Pay 3 which was appealed, and so which we're going to talk about, concerned payments in respect of holiday which he'd not taken during the 14 years of his working life with Sash Window Workshop. Okay. So how was he going to claim holiday pay for holiday he hadn't taken? Well, the argument went something like this, and I am simplifying, of course. But these were the steps. The working time regulations give him a right, which was now accepted by the employer, to a set number of holidays per year to be paid at the right rate. Okay, post-employment tribunal, that was accepted. He'd not, in fact, taken that number of days holiday over various years since he started from in 1999. And that wasn't disputed. I suspect the employer didn't have the ability to dispute it, but again, that was no longer controversial. So he hadn't taken his Euro leave period in full. Thirdly, European case law, cases like Stringer, applied in the UK, established that where an employee is on sick leave, holiday which accrues during the year in question will be carried over into the following year, rather than expiring at the end of the holiday year in question. The rationale for this is that where the employee is unable or unwilling by virtue of circumstances outside their control to take holiday, then employees should not forfeit their holiday leave. In the Locke case, the European Court had recognised that employees who were not paid their normal remuneration in respect of holiday periods would have a disincentive to take holiday, i.e., he said, they are unable or unwilling by virtue of circumstances outside their control. Here, he had not been offered his proper holiday pay, agreed, and therefore there was a disincentive. Therefore, ergo, he concluded, there was a series of deductions from pay going back to 1999 when he'd started working the Sash Window. He hadn't forfeited his holiday, and therefore he was entitled to back pay in respect of holiday he hadn't taken. And the Employment Tribunal agreed with this and awarded him about £9,000. Well, the EAT overturned the tribunal's decision, and there were quite a number of reasons why the EAT felt the tribunal's reasoning could not stand, but at the end of the day, they'd left the fundamental point open. Well, what did the EAT pick up on? Well, first, the principle allowing for the carryover of holiday pay in cases of sickness was that the employee was unable or unwilling by reason of circumstances outside his control to take his holiday. Here, on the evidence, between 2003 and 2007, Mr. King did take his full legal entitlement to holiday leave, thereby showing that in some years he clearly was not prevented from taking holiday leave. And obviously, pausing there, the factual underpayment that he'd suffered in between 2003 and 2007 for taking holiday but at an underpayment had been taken care of by the award to him in holiday pay 2. Back in holiday pay 3, the EAT found there was no evidence that Mr. King had asked for holiday, which had been refused, and that the tribunal had simply assumed that he was not able or allowed to take his holiday if he had asked for it. The EAT was not prepared to assume that merely because there would have been a failure to make a proper payment to the employee, that the employee was unable or unwilling to take holiday. The EAT also pointed out the ability to carry over holiday pay during sick leave is potentially a limited rather than a perpetual option. The Schulte case indicated it was a potentially valid limitation to say that holiday had to be used within 15 months of the end of the holiday year in question, and that employees who had not used their holiday in that period could lose it even if they were unable to take it. This should, according to the AT, quote, inform the interpretation, unquote, of the working time regulations. Finally, the AT also pointed out the individual had been paid throughout this period. It would be double recovery if an individual, they felt, was able to be paid for both the time spent in work and also paid in lieu of untaken holiday leave. The employee's argument was that he was entitled to work throughout this period and be paid holiday leave on top when he had not actually taken the holiday in question. However, the EAT pointed out that the remedy under the working time regulations where an individual has been denied the ability to take holiday is not a payment of lost wages, because there are no lost wages. It's a payment of compensation. Secondly, if the employee at work has lost the holiday entitlement during the period of employment, this is not resurrected when the employment is terminated. In other words, once holiday leave has been lost, perhaps in line with an implicit limitation such as envisaged by the Schulte case, this is not resurrected by the fact that there's a subsequent termination and he's entitled to be paid out accrued but untaken holiday leave. This leave has ceased to be accrued. So it's fair to say the EAT did not agree with the Employment Tribunal on this. There is another aspect to this. Since the remedy is an award of compensation to the employee rather than a payment of wages lost for taking the holiday off but being underpaid, the claim is a unliquidated damages claim rather than a debt claim. This is very important. The Employment Rights Act allows employees to sue for underpayment of wages, provided it's a debt rather than a damages claim. It's the Employment Rights Act which allows for a series of deductions to be recovered, provided the claim is submitted within 3 months of the last of the series of deductions. The working time regulations do not have the same ability to go back into history to claim for a series of deductions. Therefore, although the working time regulations could be relied upon in principle to claim for a failure to allow holiday pay to be taken, there was not the same ability to go back into history, relying on the series of deductions point. However, although the EAT undermined the reasoning of the Employment Tribunal in this case, they didn't contradict the underlying theory that employees may be entitled to carry over holiday entitlement where there are circumstances preventing the individuals from taking the holiday in question. It's perfectly possible that in some cases an employee could establish that the knowledge that they were going to lose money and receive less than their normal remuneration did prevent them from taking holiday. In those circumstances, claims could potentially arise in relation to previous holiday years. At the moment, that route looks to be fraught with difficulty for all the reasons set out in this case. But if employees are looking for creative ways to recover holiday pay, this may open up another front in the ongoing campaign. I think employers will be very relieved about the outcome of this case, or think it's not likely to rise that often. If the fact that an employer would have paid hypothetical holiday at less than the relevant euro rate for euro leave, if that meant that employers could have to pay for holidays which had never been requested or taken, this could have compounded the misery felt by employers coming out of the Bear Scotland and other holiday pay cases. I think that the EAT's findings that the remedy where holiday has not been taken at all is compensation award rather than payment of wages is both correct and sensible and will dampen speculation in this area. Simply, the EAT have taken a very sensible approach in assuming that merely because there would have been an underpayment of holiday, it doesn't follow from this the employee has therefore been denied the right to holiday. So that's the holiday pay element. I'll deal very briefly with the pain and suffering element. The Employment Tribunal had decided that the compensation to be awarded to the individual would not take account of a case called Simmons and Castle. The background to this is that discrimination awards traditionally have an element of pain and suffering attached to them, and there are standard bands of damages called Vento, based on the Vento case. And in the Vento case, the Court of Appeal, it identified a number of general principles to look at the proper approach in relation to injury to feelings, to introduce a degree of consistency. There were 3 bands of awards for the levels of discrimination, and in essence, these are, in lawyers' imaginative style, bottom, middle, and top band Vento cases. These bands were subsequently uprated in line with inflation, following a case called Darbell in 2010. Subsequently, there was a 2013 case, not an employment case, called Simmons and Castle, and in that the court provided a 10% uplift in relation to general damages in the civil proceedings. The court held that the uplift was to apply to all tort cases other than personal injury cases. Here, the Employment Tribunal in this case decided that the Simmons and Castle general uplift did not apply to general damages awarded to the Employment Tribunal, partly because there had been an uplift provided by the Darbell case a few years earlier. The individual cross-appealed against that part of the Tribunal's decision. The EAT overturned the Tribunal's findings in relation to damages for pain and suffering. They had failed to apply the Simmons and Castle 10% uplift to awards. There was no reason for limiting the 10% increase to torts other than the tort of discrimination. Moreover, the Darbell case, which included the uprating of the Vento guidelines, had been back in 2010, and therefore it did not seem to be inappropriate to the court in 2014 to require a further uplift of 10%. So clearly we're going to have to get used to using the revised Vento guidelines, which, if my maths is correct, means that bottom band Vento is somewhere between £660 and £6,600. Middle band then goes up to £19,800. Top band Vento goes up to £33,000. So that's the case of the Sash Window Workshop Limited and Mr. Dollar against Mr. King. Final case, Reuse Collections Limited and Mr. Keith Sendall and May Glass Recycling Limited. This is a High Court decision dealing with a multitude of claims, including whether the post-termination restrictive covenants included in Mr. Sendall's contract of employment were enforceable. I'm not going to cover all of the aspects of the case. I'm going to focus on the covenants. The background: Reuse is a company established back in 2010, took over a glass recycling business which had been run by Mr. Sendall and his family. Mr. Sendall remained in employment with Reuse when the business was sold. Up until October 2012, he didn't have a written contract of employment. In October 2012, he was given a draft contract of employment which had specific provisions in relation to confidential information and post-termination restrictions. Mr. Sendall did not immediately sign the contract, and it was evident from his communications with Reuse that he was unhappy with it. However, he eventually signed it 22nd of February 2013. So great, covenants in place, away we go. Not entirely. January 2013, Mr. Sendall sets up a new business. He gave the required 3 months' notice of resignation in March. By April, Reuse, the company, was informed that Mr. Sendall had been approaching clients in relation to his new business, and they began an investigation. The result of this was the suspension of Mr. Sendall with immediate effect, pending the conclusion of the disciplinary proceedings. Mr. Sendall argued he'd been treated in a way that amounted to constructive dismissal and refused to participate. Reuse continued with the proceedings and concluded on the 1st of May that he should be dismissed for gross misconduct. Key issues in the case which I'm going to consider are: 1, whether the restrictive covenants in the contract of employment were binding on him, and in particular, whether Mr. Sendall had received a benefit in return for the covenants, and secondly, whether the covenants were too wide, and the extent to which Mr. Sendall breached his obligations owed to the company by setting up a competing business. As I say, there were many other things that were being determined by the High Court in this case. For the purpose of the podcast, I'm just going to look at 2 of them. The main restrictive covenants in the contract included a 6-month non-solicitation clause covering both employees and clients, and a 6-month non-dealing and a 12-month restriction on setting up a business to compete with Reuse. Mr. Sendall put forward that the restrictive covenants were not enforceable because there was no due consideration, unquote, given to him in return for the covenants in the employment contract. Court found that it's an established principle that where an employer wants to impose substantial new obligations on an employee, it needs to show some real monetary or other benefit which would cause the employee to enter into the restrictive covenants. Reuse claimed that there was consideration: 1, because the employment contract continued; 2, he'd had a pay increase and was given a bonus; 3, he had continued employment. The court wasn't receptive to the position presented by Reuse on any of these grounds. First, the court found that although the employment contract did contain an addendum of benefits, car, life assurance, etc., the vast majority of these benefits were already enjoyed by Mr. Sendall, therefore did not amount to a new consideration. The difference turned on the distinction between the existing 2 times life assurance benefit as compared to the 4 times life assurance benefit offered in the new contract. The court placed particular emphasis on the fact there was no evidence to suggest that this upgrading was part of an enhanced scheme of benefits offered to senior employees, and therefore there was no linkage between this benefit and the restrictive covenants. Secondly, the court decided that although Mr. Sendall received an increase in salary from 1st January 2013, this is not reflected in the contract of employment, which referenced the old salary, and there was no reference to this being awarded in connection with Mr. Sendall entering into the restrictive covenants. The salary increase was not conditional upon entering the new contract, or even more generally connected with it. It was just a salary increase. The 20% bonus received by Mr. Sendall at the end of the year was not shown in any way to be linked to or mentioned in the contract of employment. The court quickly determined that merely continuing employment would not be sufficient in a case where a long-standing employee was asked to enter into substantial restrictive covenants. The judge concluded by mentioning that in principle the need for consideration also applied to the confidentiality clauses in the contract, especially as the clauses were drafted widely, so potentially imposed a significant obligation on Mr. Sendall. And the confidentiality clauses went far beyond what would apply in the absence of an express term, and so they were also not enforceable. There was some debate in relation to whether any consideration had to be adequate, or whether it was enough simply to point to the existence of some consideration. Judge Comity thought it would be a question to consider in relation to a finding of whether or not the covenants were reasonable, and not relative to consider when finding whether the covenants were established. Since the restrictive covenants here failed on the first hurdle, the judge did not shed any light on whether any such salary increase or bonus would be deemed to be adequate for restrictive covenants in the contract. The court went on to determine whether Mr. Sandler breached his duties during the term of his employment contract. The court established that there had been a breach of the duty of good faith and fidelity, since Mr. Sandler had actively set up the competitor company to compete directly with Reuse whilst he was still employed by them. Mr. Sandler contacted customers and suppliers with a view to assisting business and arranging financing of the company during working hours. As a result of this finding, the court ordered Reuse was entitled to recover over £50,000 in damages for loss of business. The case serves as a useful reminder of the need for due consideration when employers are asking employees to sign up to restrictive covenants or, indeed, wide confidentiality clauses. It's important to establish a clear link between any salary increase or bonus with the restrictive covenants, ideally by way of making the salary increase or bonus conditional on the employee signing up to the covenants. One factor which remains unknown is the approach that will be taken by the courts in relation to the question of whether the consideration needs to be adequate, as the current position is now uncertain following the comments in this case. I certainly think the case is an important one. It's a trap for employers and their advisors. Recontracting, I think, can usually arises three ways. It can arise where someone has been promoted, or their employment has been terminated and new covenants are being imposed, or generally as part of a recontracting exercise. For example, following a 2P transfer. The need for consideration is a need for some real monetary or other benefit, unquote, to be conferred on the employee for the purpose of causing the employee to agree the restrictive covenant. And it obviously needs to be substantial and not nominal. In relation to cases of an employee's promotion, it ought to be relatively straightforward to link the employee's acceptance of the new restrictive covenants to the promotion. In those circumstances, I think it's unlikely that an employee will kick up a fuss. They're too busy out celebrating their promotion. Where a workforce generally, or a segment of it, is being recontracted, so that new covenants are being imposed, that's trickier. In our experience, employers will often not want to offer a financial benefit in return for the new contract. The court in this case did not agree that the benefit was continuous employment with the employer following the reorganisation recontracting. But I think they accepted implicitly that continuous employment might be such a benefit. However, it was necessary for the employer to make it clear to the employee that if they failed to sign up to the covenants, then their employment was not likely to continue. At the very least, some wording would be put into the contract with an acknowledgement by the employee that the continued employment opportunity is the benefit given for the restrictive covenants. It's clear this approach might be open to challenge, but the employer will be in a stronger situation than if nothing is said. I think as well many employers would balk at expressly making a threat to employees that they would be dismissed if they did not sign up to the new restrictive covenants. It would be easy to say something in writing on the boilerplate recontracting wording. Finally, in relation to covenants that are being entered into on termination, there will usually be a payment or other consideration. Therefore, apportioning a real sum of money to the restrictive covenants is going to continue to be sensible practice. Bear in mind, if the covenants are merely being restated, they're existing covenants and they're merely being restated in the termination documentation or the new contract, there's no need to offer additional consideration. I've sometimes seen clients who want to offer, princely sum of £100 for a new set of restrictive covenants, and I've always been concerned about that. After this case, I think it's clear that that would be an unwise course of action. Either the court might find there's not been substantial and more than nominal, unquote, consideration, or the court could find that it was relevant to whether or not the covenants should be enforced, if the consideration was not adequate for the obligation being imposed. Perhaps we're starting down the path towards the ultimate destination of the approach adopted by some other European jurisdictions, where there is some form of evaluation between the impact on the employee's earning capacity and the need for payment by the employer to cover the period of the restrictive covenant. Finally, something I did not know until our most recent training session here, which covered this case, an employer cannot get around this case safely by putting the covenants into a deed. An old case, Hutton and Parker, from 1839, indicates that a deed under seal does not remove the need for consideration in this context. I wonder if 1839 is the oldest case I mentioned during the podcast this year. Answers on a postcard, please. Okay, so that's the case of Reuse Collections Limited, Mr. Keith Sendall and others. So it only remains for me to wish everyone a Merry Christmas and a very Happy New Year. I would also like to point out that in addition to being the only podcast which is not sponsored by Audible Books, we are also now one of the very limited band of lawyers who have not been pumping out advice to their clients this month on how not to be having problems coming out of staff parties caused by wild and crazy staff doing wild and crazy and unsuitable things. I really do wonder where those staff parties are that create so much work. I have to say, I don't think I've ever been to one myself. So, thanks very much for listening during 2014, and I look forward to joining you again in 2015. Bye.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.